American due process of law. In America, what is due process of law? And the reason why I say American due process of law is because while due process hails back to the time of the Magna Carta, over the centuries, different countries and different jurisdictions have taken their own approach to what they considered due process of law. It is a simple proposition that individuals must be afforded certain legal rights when they are being prosecuted from the state. It has evolved from that to apply to all cases, but more importantly to criminal cases that involves the state going after an individual. In America, the Seventh Amendment preserves the person's right to civil trials. Then the 14th Amendment requires that state also follow the baseline protections of the federal due process of law line of inquiry. So, and the Fourth, Fifth, and Sixth Amendments, which is applied to the states by way of the 14th Amendment, spell out required legal processes that must be afforded to anybody being criminally prosecuted by the state actor, whether that be federal or state. In America, we also have a distinction between procedural due process, as written out in the Constitution and as applied to the states by the 14th Amendment, and substantive due process, which is unenumerated constitutional right, unwritten constitutional rights that are also applied to the states by way of the 14th Amendment. So I received some critique about not being clear about what due process of law looks like. Due process of law means that in a legal proceeding, you get a set of processes starting from filing a complaint all the way to filing an appeal and everything in between that lawyers and courts have to follow based in civil cases on the rules of civil procedure and in criminal cases under the rules of criminal procedure that abide by the Constitution of the United States' Fourth, Fifth, and Sixth Amendments. And the Seventh Amendment preserves civil trials. So in civil trials, it starts out like this. The process is that you file a complaint with the court clerk, you give notice to the defendant replies, there's a court hearing, then they go into discovery. What is discovery? Discovery is when both the defense and the plaintiffs in a civil case or prosecution in a criminal case presents each party with whatever evidence that they have regarding the case. And that is exchanged between the parties to be able to build a better picture for the fact finder. So once that discovery happens in civil court, there's court hearing, you can decide to settle, the court can look at the evidence gathered, and then one of the moving parties can say that there's not enough evidence for us to move forward to a trial, therefore it must be dismissed. If the court agrees with that, it is dismissed. If there's a settlement, there's a settlement. So if there's not a settlement, if there's not a dismissal, it goes into trial. If there's a jury trial, there's jury selection. At trial, there's presentment of evidence and witnesses. The judge is the arbiter of what evidence comes in for the determination of the trial and determination of the facts based on rules of evidence. Then the opposing parties have the right to cross-examine their opposing witnesses. And then the jury or the judge, depending on if it's a bench trial, which is judge, or a jury trial, which the defendant gets to pick, there will be a verdict. And the verdict is either the defendant is liable or not liable, and then there's an appeal from that. So that's the civil procedural, basic, very short summary of how civil procedure goes. There are a lot of steps there that I've not mentioned. There are a lot of pre-trial processes. Then there are trial processes. And There are nitty-gritties, but generally speaking, I gave you a basic skeletal framework of civil due process. Now, in criminal due process, it's governed by the rules of criminal procedure, as I said. A finding of probable cause leads to an arrest. A grand jury finding of inquiry based on preponderance of the evidence results in an indictment or not. If there is no indictment, then the case goes away and the defendant is not liable. If the grand jury finds that there is enough evidence in front of them to indict, then there's an indictment. You have, under the due process of law provisions, the right to counsel that attaches and the right to speedy trial that attaches when you go into between indictment and trial. Then there's the pretrial process. Determine if it's a trial by jury or judge. It's the defendant's choice. If it's a jury, then it goes into jury selection. Then there's discovery. Like I said, discovery is both parties exchanging whatever information they have on that particular matter with each other. With criminal cases, there's such a thing called a Brady violation. So the Brady law says that the government is required to turn over to the defense any exculpatory evidence or any evidence that would acquit the defendant or mitigating circumstances that will lower the culpability of the defendant. They are required by Brady to turn that over to the defense. If they don't turn that over to the defense can object to it, and that may be the impetus for ending the trial right there and ordering for a new trial, or just not having the trial at all because the exculpatory evidence renders the defendant innocent. So let's say there's no evidentiary problems there and the Brady thing is fine. Then there's evidentiary hearings if needed to determine whether certain evidence can come in based on whether it is probative, means it proves something, or whether it is prejudicial. So the balance of whether the evidence is more probative or more prejudicial towards the defendant determines whether that evidence can come in or not. If it is more probative and not as prejudicial, then it is generally allowed in. And if it is prejudicial, then the judge decides that it's not allowed in. Then there's a trial, or there's a plea, or there's a dismissal, depending on the circumstances. If there's a trial, then there's a right to face your accuser and present witnesses on your own behalf. There's a finding of fact that happens by jury or judge, depending on who the defendant picks. Then you face your accuser. The finding of fact, there's prosecution and defense present evidence and witnesses. Judges decide what is allowed, like I said, based on the rules of evidence. There's cross-examination of opposing witnesses. Jury or judge decides on the basis of the facts and the law whether there's guilt or no guilt. Then there's a verdict, and based on the verdict, there goes into the appeal process. And there are also rules of appellate procedure that govern how appeals are to be handled. And in civil procedure, there are rules how you can appeal even before a case gets started or during the time the case gets started, called an interlocutory appeal, which takes up a matter to the appellate court that would be dispositive for the trial case if this particular issue was resolved, and this issue cannot be resolved after the trial happens, because then it would render this particular issue moot, or it would be a waste of the court's time, on the other hand, to go through the trial process knowing that this interlocutory appeal issue will likely dismiss the case against the defendant to begin with. So That's procedural due process of law. And that's, again, a very skeletal understanding of how due process of law works. In the criminal procedure, the rights that are vested in the 4th, 5th, and 6th Amendments are spelled out in procedure and applied so as to not have the state overreach into the individual's private rights. So it's very important in our jurisprudence that the defendant in a criminal case be afforded every constitutional protection that has been enumerated in the Constitution in order to get due process of law. And without that, your holding and your legal proceedings are illegal. Mind you, immigration courts are not Article 3 courts. They're Article 1 courts that enforce immigration law. So that procedure is a whole lot different than this Article 3 court basic structure for federal courts. And state courts have different procedures as well, but they have to follow the baseline requirements of the federal Constitution. They cannot deny the basic protections provided in the 4th, 5th, and 6th Amendments. And if they do, that would be unconstitutional and be grounds of dismissal for the case. Now, in American jurisprudence, there is such a thing called the substantive due process of law. It is unwritten constitutional rights that emanate from the Bill of Rights but are not explicitly written. They form, according to Supreme Court dicta, a penumbra of rights that are implicit in the concept of ordered liberty with deep roots in American history and tradition. If deeply rooted and implicit in the concept of ordered liberty, and that sentence, implicit in the concept of ordered liberty and deeply rooted in American history and tradition, is a judicial inquiry that the judges make. And then if there is that right that is implicit and deeply rooted, then the court has to give it the highest level of protection, which means that the law by the state has to have a compelling interest and a narrowly tailored law in order to circumscribe that particular right. And if they don't have a compelling interest, and if the law is not narrowly tailored and very, very specific, then that right wins, and the lack of compelling interest causes the state's case to go away. The state loses in that case. Mind you, this substantive due process rights come into play when the state is encroaching on individual rights, and individual rights that are unenumerated in the Constitution. So, on the basis of whether the court determines if it's deeply rooted in the history and tradition of America, and whether it is implicit in the concept of ordered liberty, and if it is, however the court determines those philosophical terms, it gets the highest protection. If the court thinks that it is not the highest protection, but it is an important individual liberty, but it's not a fundamental liberty interest, then the law has to be substantially related to further an important government interest. So it's a little bit more relaxed from the government, that the government has to show that it has an important government interest, and the law that they have drafted and passed is substantially related to that. Now, if the court determines that the right being contested is not a fundamental right at all, which they, I believe, incorrectly did in Dobbs, even then, even when it is a low-level liberty interest, the lowest standard of constitutional inquiry applies, where the law remains in place if it is rationally related to a legitimate state interest. So, when it comes to the issue of reproductive freedom, a woman's right to choose whether or not to terminate their pregnancy, Dobbs took that from being a fundamental right that gets strict scrutiny, for which states have to have narrowly tailored, and they need to have a compelling interest in stopping the abortion from happening. The court has given the government the leeway now to say that we can come up with laws that prohibit abortion as long as they are rationally related to a legitimate state interest, here it being the sanctity of life. But that's why you will see a lot of times, if there's an absolute bar of abortion in states, that often does not fly when it gets to SCOTUS, even under Dobbs, because Dobbs will apply the reasonable basis test. And if it's an absolute abortion ban, then that would include ban on abortion caused by rape, incest, and that risks substantially the health of the mother more than the health of the fetus. And these three instances are where the state has no legitimate interest in killing women, in having women raped, or in perpetrating and perpetuating a culture of rape. Therefore, there is no legitimate interest to not have those exceptions. And these rights that I'm talking about vary everything from, they're basically choice and privacy rights, associational rights and organizational rights, familial rights, right of bodily autonomy, like we see in the case of a woman's right to choose whether or not to terminate their pregnancy, the right to consent before your bodily autonomy is somehow intruded by the state. Then you have associational rights that involve your right to speech, where you go and speak, who you associate with when you speak. These are rights that emanate from the Bill of Rights, but are not enunciated in the Bill of Rights. So they have in them intrinsic elements of privacy and choice, which the Bill of Rights provides, which gives, along with its deeply rooted history and tradition in America, as well as implicit in the concept of ordered liberty, those rights that have been in American society but without constitutional protection, like having a family, like starting a business, or buying a property. Those are property rights. Then you get the right to privacy. Bodily autonomy is the biggest right to privacy thing that I can think of. Right to marriage is also a right that is deeply rooted in American history and tradition and implicit in the concept of ordered liberty. But the question comes up with same-sex marriages. The issue is not of marriages. If you look at it overarchingly, marriage is a deeply rooted right. But is same-sex marriage also the same because marriage is deeply rooted? That is a question that this court may take up if it were thinking about overturning Obergefell v. Hodges, which gives same-sex couples the right to marry. So this is due process of law, very briefly, in the United States. If you have any questions, and if you still think that I'm not being clear about it, please let me know in the comment box where you would like me to explain more, and I'll be happy to do my best to explain that to you. With that said, thank you so much for listening, and please remember to like, share, and subscribe, and I'll talk to you soon.